आप लोग इतने गंभीर हैं कि मुझे लगता है कि यह समारोह भी बड़ा गंभीर है। दिल्ली में शनिवार को सुप्रीम कोर्ट के जिला न्यायपालिका के राष्ट्रीय सम्मेलन में पीएम नरेंद्र मोदी ने अपने चिरपरिचित अंदाज में यह लाइनें कहीं तो मंच पर मौजूद चीफ जस्टिस डीवाई चंद्रचूड़ भी मुस्कुरा दिए। पीएम मोदी ने दरअसल न्यायपालिका के बेहद गंभीर काम को देखते हुए यह टिप्पणी की। उन्होंने कहा कि देशवासियों में न्यायपालिका का इतना सम्मान है कि कभी उस पर अविश्वास नहीं किया गया। पीएम नरेंद्र मोदी ने कहा, भारत के लोगों ने कभी सुप्रीम कोर्ट न्यायपालिका पर अविश्वास नहीं किया, इसलिए सुप्रीम कोर्ट के ये 75 साल मदर ऑफ डेमोक्रेसी के रूप में भारत के गौरव को और अधिक बढ़ाते हैं। सुप्रीम कोर्ट के 75 वर्ष ये केवल एक संस्था की यात्रा नहीं है, यह यात्रा है भारत के संविधान और संवैधानिक मूल्यों की। यह यात्रा है एक लोकतंत्र के रूप में भारत के और परिपक्व होने की। प्रधानमंत्री मोदी ने कहा, न्याय में देरी को खत्म करने के लिए बीते एक दशक में कई स्तर पर काम हुए हैं। पिछले 10 वर्षों में देश ने न्यायिक बुनियादी ढांचा के विकास के लिए लगभग 8,000 करोड़ रुपए खर्च किए हैं। पिछले 25 साल में जितनी राशि न्यायिक बुनियादी ढांचा पर खर्च की गई, उसका 75% पिछले 10 वर्षों में ही हुआ है। आज महिलाओं के खिलाफ अत्याचार, बच्चों की सुरक्षा समाज की गंभीर चिंता है। देश में महिलाओं की सुरक्षा के लिए कई कठोर कानून बने हैं, लेकिन हमें इसे और सक्रिय करने की जरूरत है। महिला अत्याचार से जुड़े मामलों में जितनी तेजी से फैसले आएंगे, आधी आबादी को सुरक्षा का उतना ही बड़ा भरोसा मिलेगा।
At the cost of repetition, my lord, I advisedly did not, my lord, raise any issue whether core is right or TRF is right or Perkins is right or one is wrong and other is partly right. Whatever your lordship finally decides will govern the field. Your lordship need not go into individual judgments, my lord. On principles, my lord, we have addressed your lordship. There are, my lord, several other institutes. Yesterday I came to know, my lord, banks. They have small deposits, but they follow this kind of procedure, and the arbitrators are appointed by such institutes. And if your lordship sees, my lord, the board of governors or advisory council, eminent people, my lord, former judges of this court, Justice Sri Krishna, former Chief Justice, my lord, Justice Lalit, etc., they are there. So these are, my lord, well-recognized institutions dealing in arbitrations running into the quantum running into some $1 billion. But individual claims are smaller. It's meant for smaller.
Now, who's going to argue now?
Grateful.
Mr. Padmanabhan?
I'll take just 3-4 minutes, But to supplement the argument of Mr. Guru Krishna Kumar, that 11.2 is conditioned by 12.3 or section 12 itself. Lord, my point would be, Lord, Act doesn't bar appointment by one party. That has been argued by everyone. Lord, the further submission would be that there is an implicit recognition of one party appointing an arbitrator. For that, Lord, I will just highlight two sections, 11.2, 12.3 and 12.4, and then coming back to 11.6.
Yes.
Lord, 11.2 I need not read, Lord, I read, so many people have read, my lords. But I'll just read, Lord, what happens, my lord, if once an arbitrator is appointed by one party, Lord, whether the other party can challenge that appointment? If yes, my lord, under what circumstances? Lord, answer lies in 12.3 and 12.4.
Yes.
Lord, 12 starts with, my lord, obligation on the arbitrator to disclose the circumstances, if any. Lord, 12.3, an arbitrator may be challenged only if circumstances exist that give rise to justifiable doubts as to his independence or impartiality. Here, my lord, where the arbitrator himself discloses, the party may continue, waive the rights under section 4, or he may say, I don't want you. Lord, then, my lord, 4, a party may challenge an arbitrator appointed by him in whose appointment he has participated only for reasons of which he becomes aware after the appointment has been made. Where, my lord, this, my lord, takes into a situation where arbitrator doesn't disclose. Lord, these are the only two situations, my lord, under which, my lord, an appointment of an arbitrator can be challenged.
Yes.
Lord, there is no challenge prescribed that appointment made by one party can be challenged by the other party on the ground that it has been unilaterally done. Because the 11.2 itself, my lord, is an agreement between the parties to appoint an arbitrator.
For 12-4, what's the other one?
12-4, my lord, is a situation where, my lord, arbitrator doesn't disclose.
What is 12?
Pardon, my lord?
12-4 and 12-6.
12-3 and 12-4, and then finally 11-6, my lord.
Just a follow-up of this would be, Milos, wherever this is Milos, presuming what Milos, the outcome of the judgment would be, Milos, speculating that. But Milos, application of section 15 would be, Milos, required instead of asking parties to go and file a 11. Milos, wherever these parties are impacted by a clause which this court ultimately holds is bad, Milos, they should move for a substitution under 14 and get an arbitrator appointed in 15, so that Milos, the arbitration can commence from the stage it was stopped, rather than Milos, setting the clock back. I'm so sorry.
Hardly matters. Second.
Is appointed under the same procedure as far as the original arbitrator is concerned?
Yes,
The
Milos.
15.
Yes, Milos. But if
No,
this honorable
because,
bench,
suppose because of some incapacity or something, arbitrator A is appointed
Lordship.
and he has to be substituted. The substituted arbitrator gets appointed in the same process as arbitrator A was appointed, or what?
Yes, Milos. There is an application that can be moved before the court, Milos, and the court will Milos, give due credit to the clause. But if the clause itself has been Milos, held to be illegal or not valid, then Milos, court would
Suppose there's no reference to the clause about invalidity or anything. A particular procedure is prescribed under which A is appointed, A becomes incapacitated, then B is to be appointed by following the procedure
same procedure.
leading to appointment of A. Is
Same
that
procedure without interference of the court, Milos, in normal courts. If there is no interference of court,
correct.
the same procedure will be applied. So, Milos, it should not be Milos, a case where everybody is made to file a fresh section 11. Wherever any party is getting impacted in an ongoing arbitration, it should be a case for substitution from that stage. So, Milos, their grievance is also met, Milos. That so that yes, Milos, that's all. Grateful, Milos.
We have some interveners. Now, can the interveners really give us all a set of submissions? Because otherwise there'll be no end to it.
Well, I've the first of the, because I've given your lordships my skeletons.
All right, let's start with Mr. Jetmalani and Mr. Jetmalani.
Well, I've given detailed written submissions at 5E.
Just tell us what is your point?
I've also, my lord, proceed in the lunchtime my written submissions. So if your lordships want, my lord, I've emailed it.
Just tell us what is the main point that you're arguing?
Yes, but I have basically 5 points, my lord, and I first want to show your lordships the reference order, because my lord, an objection is taken that TRF and Perkins can't be revisited. But my lord, under the reference order, those who are opposing the ban on unilateral contracts, my lord, have to go into TRF and into Perkins and see whether they're correctly decided, because there's fundamental objection that legislative intent is manifest in unambiguous words by the 7th schedule. That doesn't provide for any ban on any of the persons mentioned in the 7th schedule to appoint arbitrators. That's not an extension. It's an extension first in TRF, and then Perkins has extended TRF to unilateral contracts. But TRF was concerned with a very limited issue, and that is the issue of when a managing director, post 2015, who had a power under an arbitration clause to arbitrate himself, once he was disqualified, could he then appoint an arbitrator? And that's the answer which they
So we got your
they
point.
held
You are
it for
saying
him.
that there's no bond, there is no ban on persons mentioned in the 7th schedule appointing an arbitrator.
Arbitrator. But that's a fundamental point, because
That's
legislative intent is clear. Now, from the 7th schedule, because if, just to give one example, if they wanted to ban appointment of an arbitrator named in the 7th schedule, they could have just added one more clause in the 7th schedule and said persons appointed by arbitrators appointed by persons in clauses 1 to 19 above. So that's
Thank you, Mr.
now just one minute.
Yeah.
But now, my lord, something on the two judgments. My lord, TRF and Perkins, my lord, in as much as, so my lord, TRF held. Now, this is the starting point.
But tell us, does the 10th schedule apply to arbitration or not?
Constitution.
Does the
No,
10th
that's
schedule?
frankly, I have not. I have.
The reason I asked you whether the 10th schedule applies
Yes.
is because the Solicitor General has now come to this side.
I see. I didn't note that. I'd have probably picked it up, but I didn't notice that move from here.
Sir, I gave reason to my.
Mr. Jitwani, you didn't know what I did. He made a declaration in the beginning.
But I can
That he
tell
will
what
sit either way.
my learned friend, when he was surprised that I came and sat here. I said, you are the best person to tackle the situation where one party who is supposed to be in opposition sits together and you represent them.
But in an extension to that animal kingdom reference of wolves and he's running with the hare and hunting with the house. Good.
It's not.
Now, of the reference order itself, if I am to argue, if I am to defend unilateral contracts, I have to say a word on TRF and Perkins. Now, I've given a detailed submission dissecting those judgments, but just if your lordships want, I'll hand over and my submission on those two judgments. I'll just give your lordship. It's very. I'm going to read it out basically. It won't take me more than 5 minutes.
All right.
But really 3, 4, and 5 are the ones about the three leading judgments that impinge in this case, this reference.
It's in fine print.
And then, my lord, just 6, 7, and 8, my lord, is a defense against, my lord, the much maligned NBFCs. Now, my lord, I'll start from clause 3. TRF held an MD who had also an additional distinct power of appointment, ineligible to appoint an arbitrator, because, my lord, in my respectful submission, it fallaciously conflated the power to appoint an arbitrator with the power to delegate its own powers to appoint an arbitrator. Well, I've dissected that judgment in detail in my 25-page written submission. It thus invoked the maxim, qui facet per alium, facet per se, i.e., what one cannot do, he cannot do through another. The arbitrator is an independent appointee and not the alter ego of the person appointing him. Well, that's as far as TRF is concerned. Then, Perkins extended it to all unilateral contracts. Perkins extended the principle in TRF to all unilateral contracts on the basis of what it construed to be the rationale in TRF, that the arbitrator appointed by a person ineligible to himself act as an arbitrator by virtue of the disqualification of the 7th schedule has an interest in the outcome of the dispute. And if this was the case, thus in a case where only one party had a right to appoint a sole arbitrator, its choice will always have an element of exclusivity in determining or charting the cause for dispute resolution. Now, Lord Kaur, which is directly in point, but Lord, indirectly the other two judgments, because Lord Kaur dilutes the absolutism in TRF and Perkins on the ground that the unilateral clause it dealt with offered the counterparty a choice of appointing one from a panel. It thus opened the door for upholding unilateral arbitration clauses depending on the facts of the case. The facts prevailing in the intervener's case are far better than the facts in court. Now, this is in the alternative. But the first is that TRF and Perkins were wrongly decided. Then, my lord, in the alternative, I'm on better footing than the clause. Now, my lord, public policy is something your lordships talked about yesterday, my lord. There's a public interest element in the lending activities of NBFCs. NBFCs, in addition to wealthy lenders, also lend to segments which banks do not reach in spite of the same prudential lending norms as are imposed on banks. Now, Lord, a large segment of the applicant's borrowers are low-income borrowers whose savings are in gold and particularly gold ornaments. The intervener lends against these assets and thereby assists both the growth of the economy and the capital markets. India's status as the fastest growing economy in the world today is based on domestic demand, and which in turn is fueled by liquidity afforded inter alia by NBFCs who reach segments not reached before. Then, my lord, the strength of the capital markets is sustained by retail investors. Several of the small borrowers of the NBFC who pledge gold against loans invest the same in the capital markets where they get a higher rate of return. Now, my lord, the intervener, coming to the facts of this case, and that's my last two clauses. The intervener is a public limited company with a large number of individual shareholders, but I have to protect them. There are large defaults in repayment of loans advanced by the intervener. For recovery of loan amounts between 50,000 to 20 lakhs, there are a large number of individual borrowers who are in such default. The intervener is accountable to its shareholders and hence in respect of these loans has adopted the relatively cheaper and speedier remedy for recovery of their loans, i.e. invocation of the arbitration clause under the loan agreements. A large number of borrowers do not respond to arbitration notices in spite of service of those notices. Almost all the disputes do not require elaborate hearings or trials involving witnesses. Evidence is almost entirely documentary, and the scope of the dispute is narrow as loans and non-repayment of the same are undeniable. Arbitrators are chosen from a panel of lawyers with 10 years experience who have no relationship whatsoever with the intervener or the dispute and do not fall foul of the 5th and 7th schedule. In view of the repeated recorded absence of the borrowers, several arbitral awards are passed ex parte.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।